Okay, let's go ahead and get started. Welcome, everybody, and thank you for joining us this morning. My name is Miles Hanson. I'm with World Trade Center, Utah, and we welcome everybody who's joining us now on Zoom, those that are watching on YouTube now and later on. I'm super excited for today's topic. We're going to be talking about potential changes to immigration law now that we have a new presidential administration in Washington, D.C. And I actually worked on immigration issues pretty closely earlier on in my career. I spent 2 years in Armenia building up a visa program so that Iranians that wanted to come to the United States could come and apply for visas. And we did interviews with everybody and worked hard to try to figure out who were those that qualified for visas and wanted to come to that we wanted to allow to come to the United States, and who would be better not to come. But I was right there, on the front lines in the trenches of U.S. immigration policy, and I saw both how important it is for people around the world to be able to travel to the United States, to do business, to get educated, to make investments, to visit family and friends, and also how we need to have strong programs to make sure that we are screening people who are coming here, especially working with a country like Iran. Not everybody wanted to come here with good intent. I also experienced firsthand how frustrating our immigration policy can be, both for those who are trying to go through the system, whether it's a foreign person or entity, or U.S. companies that are working to try to get their people here to the United States. We have a very frustrating system. It is broken. It is in desperate need of modernization and reform. But until we get those things, and before Congress decides to act on that in a decisive way, what we end up with are typically executive orders that can change pretty quickly from one administration to another. And so here today, we're going to be talking about the way things have been with the Trump administration and what some of those changes could be and what the implications will be for our Utah companies that are working hard to figure out how they can get people coming to and from the United States as quickly and smoothly as possible. And so a huge thank you to our friends at Parsons Behle Latimer. Thank you, Jason, for reaching out on this. And a big thanks to Mike Bailey, who is a board member at World Trade Center Utah and a partner at PBL. Thank you both for your partnership. And we've done a series of these webinars, always super informative. And we appreciate you sharing your expertise with our companies. And a big thanks to today's speaker, Jacob Muklevich, who is an expert on immigration law. He's going to have some slides that he's going to run through for us. We want to make sure we save some time at the end for questions. And so you can ask some specific questions and get some good guidance from our friends at Parsons Behle Latimer. And Mike, real quick, do you want me to go ahead and read Jacob's bio, or do you want to do that yourself?
No, I'm happy to do that, Miles. Thanks so much.
Perfect. And that'll be, I'll go ahead. We got a lot of ground to cover. Mike, I'll go ahead and pass the baton over to you.
Sounds great. Thanks, Miles. And as a board member of World Trade Center Utah, I've really enjoyed the friendships and business contacts that I've made. And I have to say that on behalf of Parsons Behle Latimer, we have thoroughly enjoyed the partnership with World Trade Center Utah. I've enjoyed doing these webinars. And, I was just saying to Hannah that when you get to know an organization, sometimes the better you know it, you start seeing fleas. World Trade Center Utah is the opposite. The more I work with you guys and the more I know about you, the more impressed I am. So thanks for all of that.
Thanks, Mike. I appreciate that.
Today, we brought you an interesting and, given the recent change in the administration, a very timely presentation. There's a chat room feature, and if you'll just go ahead and put your questions in, Jason Castor of Parsons Behle Latimer is going to manage those questions, and then our presenter, Jake Muklevich, will answer those questions at the end of the presentation. Our presenter, Jake Muklevich, was born and raised in the heart of the Rust Belt in Steubenville, Ohio, where his father and grandfather worked in steel mills on the Ohio River. Steubenville was a melting pot where people from different countries lived and worked together in the steel mills, coal mines, and factories. It was actually the perfect childhood for someone who would later practice immigration law. He obtained his bachelor's degree in international relations from Brigham Young University in 1998 and JD from the Ohio State University Moritz College of Law in 2001. After graduating from law school, Jake planned on practicing U.S. Customs and trade law, but after working on business and employment-based immigration cases during his first year of practice, he felt great satisfaction in representing companies and individuals who, like his Polish ancestors, were pursuing and fulfilling the American dream. Jake's practice focuses exclusively on business and employment-based U.S. immigration matters. As Jake works together with companies and their professional personnel from overseas on devising and implementing U.S. immigration and visa strategies, he appreciates the opportunity to pass the torch of the American dream that he inherited from his Polish ancestors to each of his clients. Now I would like to welcome up to the microphone, Jake Muklevich.
Mike, thank you so very much. Miles, thank you for having me this morning. It's truly a pleasure to be here, not only online and via the media that we have, but to be here in the United States. It truly is an honor and a privilege and a blessing to be part of the fabric of this country, to be a member of the family of the United States of America. I'm here because of the people who came before me, and there are many others that are looking to fulfill their personal dreams and aspirations. And it's my privilege to work together with you, the World Trade Center, members of our business community, and making that dream a reality for those who want to come, as did my family. I wanted to start this morning with a Polish proverb. Since we've already heard my last name, Muklevich, I figured we would see a few more consonants strung together. And this will be a good segue into where we are today. So I grew up hearing from my Polish grandparents, aby mierzyć drogę przyszłą, trzeba wiedzieć skąd się przyszło, which translates as, in order to gauge the road ahead, one must know from whence he has come. So we have a new president in the White House. We have a lot of things that are happening daily, even by the hour, via executive order, via announcements of possible legislation through our new Congress. So today, I want to follow Cyprian Norwid's counsel and looking to see what road we've traveled the last 4 years and see where we're at today and where we might be going. I know that there's a lot of interest, a lot of anxiety, a lot of hope, a lot of mixed feelings as to where we're at today and where we may be going. So let's take a look at where we've been the last 4 years and where we're at today. But let's start with the Trump administration. What happened? When President Trump entered the White House in 2017, he had a divided Congress. The Senate was under Republican control and the House under the control of the Democratic Party. So there was not a lot of hope for legislative solution for comprehensive immigration reform. So what happened was there was a score of executive orders whereby the Trump administration was trying to shape immigration policy. I had a lot of clients in 2017 that were very worried that Trump was going to have a drastic overhaul of the Immigration Nationality Act, the statutes. And as an attorney, I had to remind my clients that the president is not the emperor. He does not make the law. That is the proper role of the Senate and the House together in the Congress. However, the executive branch can significantly determine how laws are applied, interpreted, and enforced. President Trump's executive order, the Buy American and Hire American executive order, was largely what shaped several other subsequent executive orders that made practicing immigration law, that made hiring and bringing U.S. workers to the United States much more difficult. You'll notice that verbatim, part of the executive order, Buy American, Hire American, it shall be the policy of the executive branch to rigorously enforce and administer the laws governing entry into the United States of workers from abroad. So it wasn't just focused on buying goods from U.S. manufacturers and U.S. sources, but this executive order gave a signal to others in the executive branch that their job was to protect American workers. So following the issuance of the executive order, Buy American, Hire American, in April of 2017, U.S. Citizenship and Immigration Services, which is under the executive branch, specifically the Department of Homeland Security, issued several policy memoranda that made it much more difficult for companies to hire and bring foreign workers, professionals to the United States. I'm not going to read each of these. They're on the slide deck, and you'll have those available to you. But those of you who, for instance, may have tried to bring H-1B workers to the United States, you may have noticed that it was very difficult and frustrating as the administration encouraged the Immigration Service to challenge companies that were filing H-1B petitions. Prior to the Trump administration, it was common for employers to present to the Immigration Service an H-1B petition wherein there was a detailed job description, company letter of support, and a copy of the foreign nationals' degrees, academic transcripts. The Trump administration said that that is no longer enough. We want to see more. The Department of Labor policies, handbooks, Occupational Outlook Handbook, ONET job description summaries, they say that some of these professional positions may require a bachelor's degree, but all do not. And because all do not, your company may be one of the ones that does not require a degree. So we're now requiring you, the employer, the potential employer, to give us more evidence. If you look at the second point, the Trump administration did away with a longstanding practice of the Immigration Service. There was a memo that was geared at improving efficiency and decreasing processing times. And this memo was a memo where the Immigration Service adjudicators were not to re-adjudicate previously established facts. The Trump administration said every immigration petition should be reviewed de novo. We're giving the immigration officers authority to look at the full scope of a petition as if it was newly filed. So if you're filing an H-1B extension and you've previously shown that your job requires a 4-year degree and your foreign national has the degree, we're not going to give you the benefit of the doubt on the extension. You're going to have to prove your case de novo from square one. As a result, processing time significantly increased. There were significant increases in requests for evidence and also denials. Basically, if you look at these different policies, in a nutshell, what the government was doing was trying to make it more difficult and more expensive for employers to use the H-1B and other work visa programs, with the desire that companies would hire U.S. citizens or lawful permanent residents. Under President Trump, there was also increased enforcement. The federal government was using its executive authority to check the work site, to go into employers' public access files to make sure that the information that was presented in an H-1B case was in fact happening at the workplace. So there was much more robust enforcement under the Trump administration. And that was nothing new. The legislation had already existed prior to President Trump taking office for the federal government to look at public access files, to investigate fraud. But the Trump administration used its executive authority to strictly enforce what was already on the books. The Trump administration also was very, very interested in making public usage of the H-1B programs. They wanted to make sure that the U.S. citizenry saw who was using the H-1Bs, how many H-1Bs were being used by particular employers, to shed light on the H-1B usage. Then we had last year, we experienced a lot of travel restrictions at home and abroad. You may recall when the COVID-19 pandemic hit in the spring of 2020. Shortly thereafter, in April, President Trump issued various executive orders, one of them being a presidential proclamation, 10014. What that basically said was anyone who's outside of the United States applying for an immigrant visa would be postponed. Their visa appointment to obtain a green card would be postponed until later in the summer, in June. There were a lot of people that were very nervous. They thought it was a carte blanche postponement of all visas. But what we saw in the spring of last year was a presidential proclamation that said anyone applying for an immigrant visa, a green card, would have their visa appointments postponed until later in the summer in June. There were several exemptions that reflect family reunification and reflect various public policy interests of the United States. People who were applying for green cards, who were the spouses or children of US citizens, of course, were allowed to come into the US. Foreign nationals who were working on the front lines as physicians or medical researchers were still allowed to have their visa appointments. But by and large, a lot of people who were applying for immigrant visas on the employment side were shut out if they were consular processing their green card. Their appointments and interviews were postponed until June. Then when we hit June, President Trump not only extended the delay of immigrant visa appointments at US embassies and consulates, but he then said, we're not going to issue new H-1B, H-2B, J, and L visas to anyone who is applying at a US embassy or consulate abroad. That caused a lot of consternation. There were a lot of employers that thought that that was a complete ban on anyone extending their status inside the United States. People who were already here in H-1B, H-2B, J, or L status were of course allowed to extend their stays. They were already here. What this proclamation did was postpone visa appointments for people now applying for temporary visas. So people who had approvals but were outside of the United States were stuck in their home countries or third countries, not able to come into the US. So there was a lot of frustration and remains a lot of frustration for companies that have approvals but can't bring their people into the US. If you look at the L category, there are a lot of companies that have blanket approvals, which means they don't have to file a petition through the US Citizenship and Immigration Service because they already have blanket approval that allows their executive staff and their managerial staff to go into the embassy or consulate and apply for an L visa that allows them to come into the United States. That's to facilitate a travel to the US by international companies that have offices that are operating in the US. That can't take place right now if you haven't already had your visa issued. You're being waitlisted until these presidential proclamations expire. This proclamation was to expire at the end of the year. However, shortly before President Trump left office, he extended the enforcement of proclamations 10014 and 10052 until March 31st, 2021, which means that if you're applying for a green card or an H-1B visa or an L1A visa, L1B visa, you're now waiting until March 31st, 2021, unless our new president rescinds this order. And the question remains, where will we go now under President Biden? An interesting development less than a week before President Trump left office, and this should be of concern and interest to anyone who uses the H-1B program. The Department of Labor had introduced regulations that would have significantly increased the prevailing wage levels used for H-1B visas. So if you are an employer and you want to file an H-1B visa petition for a foreign national, before you file anything with the Immigration Service, you must first obtain what's called a labor condition application, or LCA certification, from the Department of Labor. In that LCA, the company makes various attestations. They attest that they're not using an H-1B worker to replace a striking or locked out US worker, and that the company will pay either the higher of its actual wage or the Department of Labor's prevailing wage. This is a mechanism whereby the government ensures that using H-1B workers will not have a negative impact on US wages. The Trump administration wanted to significantly increase those wage levels. So if you'll see on this slide, there are 4 wage levels. Entry level is 1, the highest wage level is 4, and you can see exactly where the percentiles were going to be moved. Basically, what was happening is the Trump administration was trying to discourage employers from using the H-1B and making the H-1B program available only to those who are willing to significantly pay higher wages. Where are we today? What's happened over this last week? There are a lot of people that were feeling a lot of anxiety, especially with the 11th hour proposals that were being made by the Department of Labor and other executive agencies under President Trump. And when President Biden took office approximately a week ago, there's a lot of hope for the future. Let's take a look to compare and contrast as much as we can, apples to apples. President Biden has what's called the Made in America Executive Order. It was originally called the Buy America Executive Order, but the wording was changed because it sounded too much like Buy American, Hire American under President Trump. If we look at the Made in America Executive Order, what's glaring is the omission of anything to do with Hire American workers. So if we look at this executive order, there's great focus on buying products made from American manufacturers, but there is not the same provision in the Trump Buy America, Hire American executive order to focus on making the employment of foreign nationals more difficult. President Biden has a different situation entering the White House that President Trump had in 2017. And the significant difference is that President Biden is working now with a Congress that is controlled on both sides in the Senate and the House by his party, the Democrats. So he has announced that he would like Congress to pass what he is calling the U.S. Citizenship Act of 2021. There are some interesting policy changes in this legislative proposal. Let's take a look at some of these. Creating a roadmap, an earned pathway to citizenship for undocumented individuals. That includes dreamers, people who have temporary protected status. TPS is a program whereby the U.S. Department of State will designate citizens of certain countries that have experienced national disaster or political upheaval as being eligible for extended stays and work authorization in the United States. There's also a provision where anyone who has a green card and can pass background checks can become a citizen after 3 years. That's offering a lot of hope and prospects for a better future for a lot of people. But how is that going to play out on the business side, the employment side? We'll talk about that. There's a proposal to keep families together and to further the U.S. immigration goal of family reunification. So if we look at some of these proposals, what's significant to me as an immigration attorney is an elimination of the 3 and 10-year bars. What does that mean? Back in 1996, the Republican-controlled Congress passed the an immigration reform bill that had significantly changed a lot of the statutes in the Immigration and Nationality Act. One of these things was the 3 and 10-year bar. What this is that if you come to the United States and overstay your visa and accrue more than 6 months of unlawful presence, then when you leave and apply for a new visa to come back, you'll be barred from re-entry for 3 years. If you overstay your visa status by more than a year, then the next time you leave, you will be barred from re-entering for 10 years. The aim of that legislation was to serve as a deterrent for people overstaying their visas and to encourage them to leave, knowing that they would be subject to either a 3 or 10-year bar. What has happened is the exact opposite. People know that if they stay and leave, they won't be able to come back. So they stay and hide in the shadows and try to avoid detection by U.S. Immigration and Customs Enforcement. So if we look at history, one of the unintended consequences of the 3 and 10-year bars is instead of discouraging overstays, we've actually encouraged people to stay here longer. Under President Biden's legislative proposal, there are diversity initiatives, increase the number of diversity visas to 80,000 from 55,000, so that we have more people from different countries that are able to immigrate to the United States. President Biden is also encouraging significant changes to asylee and refugee application procedures and making America more open to people seeking either refugee or asylee status. If we look at this next bullet point, growing our economy, this is where I think our audience as people in the business community should focus attention. President Biden's Citizenship Act proposal wants to make it easier for people to get green cards. But who are those people? One of his proposals is for graduates of STEM degrees, science, technology, engineering, and math. Anyone who graduates with a PhD in a STEM field, he would like to give them a green card together with their PhD. He wants to eliminate some of the red tape and the bureaucracy in the employment-based green card process. It remains to be seen what exactly those details are, but those of you who've gone through the work-based green card process know that it takes several years to get a green card. It's not a simple matter of filling and submitting forms to the government and getting a green card in a few months, but you go through several layers of bureaucracy. You go through the Department of Labor, the Citizenship and Immigration Service, and in some instances, the State Department. And it may take 3, 4, 5 years for a worker to get a green card. We'll see what President Biden's administration and what Congress proposes to make the system more streamlined. If we look at H-1B workers, President Biden would like to give spouses of H-1B workers employment authorization documents or work permits. Those are already available to spouses of L1 intracompany transferees, and he would like to make it available to H-4 spouses. You'll also see that there are at the bottom there is an incentive for employers to make wages higher so that they don't depress wages for U.S. workers. Which, if you look at what a lot of the things the Trump administration was saying, that's a similar point. We'll see exactly how that is put into a bill and what that means going forward. But the Biden administration, like the Trump administration, wants to make sure that there is not a depression of wages and salaries of U.S. workers, but it's hopeful to see that there's language about incentives as opposed to penalties. I think that is a good way to go forward. You'll also see that the Biden bill has a provision to protect workers from exploitation and to improve the verification process. Again, we don't know exactly what that means. Will that have provisions that radically change I-9 completion and maintenance by employers? Will that change the government's position on E-Verify? Will it go from being a voluntary program to a mandatory program? We don't know. But at the bottom of the screen, you'll see that there are proposals for increased penalties for workers who violate labor laws. You'll also see that there are protections for workers who are victims of a workplace retaliation, including workers who may be here without status, who are subject to deportation. So there's a lot more that we're seeing from the Biden administration that is trying to open the doors to foreign nationals. Now let's take a look at how the Biden administration is dealing with COVID. That was a hot topic issue during the campaign. It's kind of interesting to see that what we're seeing from the Biden administration is the travel bans, some of the travel bans that were imposed under the Trump administration may be continued under President Biden, but instead of under the argument that the bans will be used to prevent foreigners from coming into the United States to take jobs away from US workers, that these travel bans will be used to protect US citizens and residents from the COVID-19 pandemic. It was interesting that during Trump's waning hours, he was going to make it possible for citizens of the European Union, the UK, and other countries to resume their travel to the United States. But when President Biden took office, he said, no, we're going to keep the travel bans in place. The travel bans dealing with visa issuance, the immigrant visas, the green cards, and then the temporary work visas, the H-1Bs, H-2Bs, Js, and Ls, those are still in effect until March, unless they're rescinded at a later date by President Trump. You can see that the Trump administration has officially, through his press secretary, announced as late as January 26th that the travel restrictions will remain in place. And again, if you look at the language, to strengthen public health measures around international travel. The effect is the same as the Trump travel restrictions, but the language is significantly different. Under President Biden, the restriction is to protect public health, not to protect American workers and keep out foreign nationals. Now, I was very concerned the last few weeks of the Trump administration when we were talking about significantly raising the prevailing wage levels for H-1Bs and then also possibly for work-based green card cases. I was relieved to see that on January 20th, White House Chief of Staff Ron Klain gave us some direction of where the new administration is going with some of the 11th hour proposals by President Trump's executive agencies. So you can see here that everything that was put on the table during the 11th hour is being called into question and is being asked to be reviewed. When these announcements came out, the DOL withdrew the regulation that would have significantly increased the prevailing wage levels. So that is wonderful news for employers that were thinking that they were going to have to go off the charts on their pay scales in order to recruit and to hire and employ H-1B workers. However, one of the proposals under President Trump, and again, this is something that was very interesting. Those of you who've been through the H-1B program know that the H-1B annual cap or quota is a significant hurdle to overcome. For those of you who don't know what the H-1B cap is, Congress has by statute limited the number of available H-1B visas, new H-1B visas that can be issued during any government fiscal year. Currently, that number stands at 65,000. There's an additional 20,000 new H-1B visas annually for foreign nationals who have earned a U.S. master's or higher degree from a U.S. college or university. If you look at the data that the U.S. Citizenship and Immigration Service has published over the last decade, annually, USCIS receives over 200,000 H-1B applications a year. So we have a supply and demand problem. The demand significantly exceeds the supply. And so the legislation, the statutes say that when we have this type of a situation where the supply does not meet the demand, that Congress is supposed to use a lottery to determine which H-1B petitions are adjudicated. What we have had for several years is a blind random lottery where the first 5 business days of April, companies will file H-1B cap petitions, and by statute, the Immigration Service is accepting all of the newly filed H-1B cap petitions. The Trump administration, during its time in the White House, looked at this from a business perspective, and I will give a shout out to the Trump administration in saying that this system was not the most efficient way to administer the program. There were 200,000 applications being filed, and the government can only process 85,000. So what is happening in these government service centers is they're receiving hundreds of thousands of applications, knowing that they're going to be rejecting and returning over 60% of these cases. It's a waste of employers' time to go through the motions, to file, to pay FedEx to courier these petitions to the Immigration Service. And the Trump administration asked, is there a better way to administer this program? And what they did the last year was they say, we're going to have a registration program, and we're going to have everyone who's interested in filing H-1B petitions go through this registration program, which will pre-screen the petitioning employers, and then we'll limit the number of applications at 85,000 so that we're only receiving 85,000 applications. And that way we're reducing waste, we're reducing the amount of time it's taking our people to process applications that eventually are going to be sent back and not looked at in the first place. Before President Trump left office, he had another idea. He said, let's not use the registration process, let's just have a bidding war for H-1Bs. Those who promise to pay the highest wages or salaries, those will be the people who get the H-1B cap spaces. There are some questions as to the fairness and equity in the business community, how that program would affect smaller businesses and companies that want to employ people at entry-level positions that are just graduating with bachelor's degrees out of college. Of course, if you are Micron or you're a multinational company, IBM, Apple, Amazon, you have a lot of money and you can attract a lot of experienced and highly skilled workers and offer high salaries. But if you're a smaller business, if you're a startup company and you want to hire someone who doesn't have a PhD or a master's degree, but you want to hire someone at an entry-level position, if you're being priced out of the H-1B program because you want to pay someone a level 1 entry-level wage, is it fair for you not to have access to the H-1B program based on your company's history and where you're at in your business operations? So that regulation about the new way of administering the H-1B lottery, that bill should be reviewed. I hope it will be significantly revised or withdrawn during the next 60 days of the Biden administration. But from a 30,000-foot view, I think it's very easy to see that during the last 4 years under President Trump, the administration was strictly enforcing policies either through executive order or presidential proclamations to make it difficult and to discourage employers from even trying in the first place to file H-1B or L-1 petitions, employment-based green card petitions. The frustration level had increased so much over the last 4 years that I had several clients saying, it's not even worth my time and money to go through this process because I don't know what's going to happen. There wasn't the same amount of transparency an expectation as there was, because there were so many executive orders coming out, so many new ways of enforcing and interpreting existing statutes, that during that period of frustration and unknown, a lot of people said, we're going to wait. We're going to wait and see what happens, which is where we are today. What's going to happen? I'm hopeful, but I'm cautiously optimistic. I realize that with any new administration, there are different priorities. And as I look at this new bill that's been proposed by the Biden administration, a lot of it focuses on family reunification. It focuses on humanitarian issues. There are provisions that will streamline green cards for the business community, but a glaring omission in the bill is what's going to happen with the H-1B program. I know a lot of people here in Utah, especially in Silicon Slopes, have been concerned and frustrated by the lack of H-1B visa numbers. So what do we do? What should the business community do? From my perspective, as someone who collaborates and works with the business community, I would say let's learn from history. Let's learn what has worked in the past and what hasn't worked. What has not worked are requests and bills that go to Congress to increase the number of H-1B cap spaces. I know a lot of people who've been practicing or been working in this field remember the days when we used to have 195,000 new cap spaces available each fiscal year. You used to be able to get an H-1B, a new H-1B at any time without having to worry about the cap. Those numbers were significantly reduced to 65,000 16 years ago in 2005. And ever since that time, there have been people lobbying Congress saying, let's increase the caps again. And what I have seen is people who are opposed to the H-1B program say, look, we've made compromises in the past. We've made the H-1B training fees and surcharges higher to make greater pools of money to train U.S. workers, but that's really not happening. U.S. companies are still hiring foreign nationals, and we're not seeing an increase in wages for professionals who are U.S. citizens or lawful permanent residents. So we're not going to increase the caps. I think it's counterproductive to keep trying that same strategy. What I would recommend is, instead of asking for increases in cap numbers, explore the possibility of making more cap exemptions. Under current law, certain H-1B petitions and certain petitioners aren't even subject to the annual quota. For instance, institutions of higher education, foreign physicians who obtain an H-1B on the condition that they work in medically underserved areas. I think it's possible to go to Congress and ask Congress to increase the exemptions, instead of saying only those who pay high wages will get access to the H-1B program. Let's rephrase that in a way to say those who pay higher wages at the level 3 and the level 4 scale, they're exempt from the cap, but we still keep cap numbers available for startups and smaller companies that want to hire people at the level 1 entry wage. Again, we could get to where we want to go, but just couch it in different language. So it seems that the Biden administration is doing that. We looked at the COVID travel restrictions. We're still delaying visa issuance, but it's based and premised on protecting public health, not on keeping foreigners out. So I think we as a business community could work with Congress and could work with the administration to pursue and further our business interests by using the same language and the same approach that the new administration is. I think doing that will be much more productive than digging in our heels and taking a defensive, aggressive approach. And with that, I welcome your questions. Thank you for the opportunity to speak with you today.
Jake, great presentation. Thank you very much for taking the time to put all of this information together. It's a great summary. Obviously, it's very messy, and we're thrilled to share some questions that have come in through the audience today. So let me start with the first one. Is there a cap for L visas, and can we expect to resume normality in the process soon?
There is not a cap to the L visas, which is one of the benefits to the L1 visa category. So unlike the H1B, there is not an L1 cap. When can we expect some normality with the L1? That remains to be seen. We're still only a week into the Biden administration, but I am pleased to see that many of the executive orders coming out from the Biden White House are rescinding or withdrawing, either in part or in full, a lot of the Trump executive orders.
Thanks, Jake. And while we proceed through questions here, feel free to submit additional questions. We've got about 13 minutes left before the top of the hour, so we'd be happy to entertain these. Next question, are there any changes on investment-based visa policies?
Yes.
Anticipated changes?
Well, there have been changes in the EB-5 program. So if you look at investment programs for foreign nationals, there are two. There are temporary investment visas, which are under the E2 temporary visa program, and then there's EB-5, which are investors that are looking to get green cards. There were changes in the EB-5 program. The baseline minimum capital investment requirements were significantly increased. It used to be that the minimum investment for an EB-5 was $1 million. If you invested in a targeted employment area, then the minimum investment was only $500,000. Now those minimum investments have increased substantially. Now the minimum investment is, I believe, 1.7 million for the EB-5. So if you're going to pursue a green card through the EB-5 program, you're going to be paying significantly more than $1 million. The employment creation requirement remains in effect. That hasn't changed. If you want to get a green card based on investment, you not only have to have the minimum capital investment, but you also have to create 10 full-time jobs for U.S. workers. The E2 investment program, that is based on bilateral treaties between the United States and other countries. So if there's a bilateral treaty between the United States and, let's say, Poland, which there is, and you are a Polish national and you invest money in a new capital enterprise in the U.S. that's at least 50% Polish owned, you can get an E2 visa. So the E2 visa is available for those nationals whose countries have bilateral treaties with the United States, but it's not available for all countries. It's not available for Chinese nationals. It's not available for Indian nationals. So if you look at the EB-5 program and see which countries are using the EB-5 the most, China and India are usually at the top. And that's because they don't have bilateral treaties that allow them to get the E2. With the E2 visa, there's not a minimum investment capital contribution amount. So there's no threshold, $1.7 million to invest in order to get the E2. To get the E2, you just have to make a significant investment, enough to cover the startup cost of your new capital enterprise.
Great response. Keep the questions coming in. Jake, another question from the audience. Will there be a method by which a person who had a permanent residence card but did not review it before it expired to renew their permanent resident status? And this is an individual who came to the U.S. legally and has been gainfully employed and paying taxes.
Okay, so if I understand the question, Jason, it's a permanent resident, it's a green card holder, and they've been here, they've been paying their taxes, but their card has expired.
Yes.
Okay. First of all, let me greatly reduce your anxiety. You are not out of status and you are not illegal when you let your green card expire. It's the document that expires, but not your status. If you've continued to lawfully reside in the U.S., you haven't committed any deportable offenses making you removable, your lawful permanent resident status is still intact. When the card expires, it's a simple procedure. You complete a form I-90, submit it to the U.S. Citizenship and Immigration Service, and they will issue you a new card. So the consequence of allowing the card to expire is that it makes traveling internationally difficult. You need to have a valid green card, a valid permanent resident card to board the plane and to come back to the U.S. and go through customs and be readmitted. But if you're still here, you're living, you're working, your card expires, you're still a lawful permanent resident. Just complete the I-90, pay the government fee and submit your application, and they'll send you a new card valid for up to 10 years. And that individual could still change jobs. And when a green card holder, this is important for our employers that are listening on the call. When you have a new hire check the box on your I-9 form and they say, I'm a lawful permanent resident, which means I'm a green card holder, that does not mean that that individual has to show you his or her green card. They may show you any other valid document that is acceptable either under list A, B, or C. So they could give you a driver's license and an unrestricted social security card, just like a US citizen could. And in this case, if this individual has let his or her green card expire, if they want to get a new job, they don't have to have the green card. They just need to have a valid form of government ID and an unrestricted social security card. So the fact that the green card is expired is not going to prevent them from working and being mobile in the US workforce.
Great. Jake, this next question is related to the NIV ban. Can you restate what Biden administration's position is on the 6/22/2020 NIV ban? And the question also includes, did I hear right that the chief of staff said it will remain on the basis of public health? And would this create an expectation of the ban staying in place through the rest of the pandemic?
That's what we're seeing. The Biden administration has not signaled or publicized any information that they are going to rescind the non-immigrant and immigrant visa bans until March. But again, the rationale and the basis for keeping those bans in effect isn't to assist with the U.S. economic recovery and to protect U.S. workers' jobs, but it's to protect public health. We'll have to see what happens within the next several days and weeks, where the Biden administration goes with that. But there are certainly people inside the Biden administration who take the COVID-19 pandemic very seriously, and they want to restrict travel. And because of that, they are not anxious to open up travel for non-immigrant and immigrant visa applicants. There is still, in effect, the national interest exception to the NIV ban. So if you are applying for an H-1B or an L-1 visa and you meet the national interest criteria, you still may be eligible to have your visa issued before March. To be eligible for that national interest exception, you have to be working for a company that is providing services in the national interest. So you're a medical device manufacturer, or you're a pharmaceutical company that's making helping make vaccinations or medicine. You're involved in food production. You can go onto the Department of State's website and look at their publication from August of last year, 2020, and they will spell out the exact criteria for the national interest exception to the NIV ban. So if you're subject to the ban till the end of March, if that's not rescinded or withdrawn, the only possible avenue to get you here before March is going to be under the national interest exception.
Great, thank you very much. It looks like we've got time for one more question. So Jake, this is the time where you pull out your crystal ball, and we, recognizing that we're only a week into the Biden administration, can you attempt to predict what is coming over the course of the next 1 or 2 years with the Biden administration with respect to U.S. policy on immigration?
Yeah,
High level.
if I had to predict, and we'll see if my predictions come true, and if they do, I'm going to give up the practice of law and I'm going to start picking horses down in Vegas. But now that President Biden has both the Senate and the House, I foresee there being a comprehensive immigration reform bill. I do see that being passed. That was a big part of the Biden administration's platform. It's part of the Democratic Party's platform. And they missed an opportunity when President Obama was elected, and a lot of people in various camps that are in the pro-immigrant community, they remember that, and they're putting a lot of pressure on the Biden administration to get something done on immigration reform. Everybody knows that we've got a lot of dreamers, we've got a lot of people that are in limbo, that are living in the shadows, and people are tired of it, and they want it to be fixed. So I do foresee, there being some type of bill passed. It's not going to be called an amnesty bill, because people remember 1986 when President Reagan had his amnesty bill. Back then, there were approximately 3 million undocumented foreign nationals. Now that number is between 11 and 12 million. So you've got a lot of people that are on the anti-amnesty or anti-reform camp that say, listen, we did this under a conservative, we did this under a Republican administration, and it didn't end well. We didn't fix the problem, we made it worse because we just invited more people for the next amnesty. That's the argument that's often made against immigration reform, is that if you reform it, you're just opening the door to the next one 10, 20, 30 years down the road. So I do see there being a reform bill, but there's going to be a lot of partisan bickering. There's going to be a lot of partisan fighting. And I think the business community needs to be not part of the fighting, but they need to come with some constructive resolutions and solutions to what ails them. Again, on the H-1B front, I think that it's counterproductive to say, give us more, increase the cap numbers, because people on Capitol Hill on both sides, Democrats want to change the system, but they don't necessarily want to change it for people who they view as potential Republican voters. They're going to play to their base, they're going to play to their constituency, and increasing the number of executive visas and high paying professional visas isn't necessarily on the top of their agenda. But if the business community can couch it in such a way to say, this is a fairness issue. These are people with families. These are people who want their piece of the American dream. They shouldn't be shut out just because they played by the rules and because they're making a lot of money, but they should have access to the American dream just as the downtrodden and those who are less fortunate financially. I think that if we can have the discussion and debate, focus on those types of issues, we can get a lot further. And I do think that we need to focus on the H-1Bs, carving out more exemptions. That provides a lot more political cover for legislators. They can go back and say, well, I didn't increase the cap, I didn't increase the visas. More people are now able to use the program because they're not counted to the cap. So we get the same thing. But that's what the Biden administration, at least what I see what they're doing. They're not saying we're keeping people out because foreigners are a threat and we don't like immigrants. They're saying we're restricting travel because it's a public policy to keep people healthy and safe. So if we can communicate with the administration and with Congress in that way, I think the next 2 years, the next 4 years, it offers some changes for some significant differences that will make people's lives better.
Jake, well said. Thank you for going out on a limb and providing us with your prediction and a great presentation and summary today. Before we conclude, I want to extend a big thanks to our audience for joining us and participating in today's webinar. A big thanks to Miles Hansen, Hannah Hutt, and World Trade Center Utah for their partnership. And Mike Bailey, thank you for your leadership at Parsons Behle Latimer and with your role on the World Trade Center board. Hannah, I'll turn the time to you.
Thanks so much, Jacob, Jason, Mike. This has been excellent. Thank you everyone who attended today. We will be sending out this recording along with the slides and their contact information so that we can keep this conversation going. Please feel free to reach out to World Trade Center Utah or to Parsons Behle Latimer with any additional questions. and we hope you have a great rest of your day. Thank you.